We'll start in few minutes as people are still joining.
We have like 11 decorum. We'll get started as people are joining. We'll just start with Mangalacharan and get proceed.
So should we start?
Yeah, people are keep joining and we'll close the Mangalacharan and introduction.
So Jai Jinendra everyone. I Alkesh Mehta, convener for today's session on behalf of Therapan Professional Forum, Bangalore Central. Warmly welcome to all the participants, dignitaries and other today's speaker Vivek Ji Sethia for exclusive webinar on the topic labor reforms in India, what every business owner should know. So, as we all know, the introduction of new labor codes marks one of the most important reforms in India's employment and compliance landscape. So, for businesses and professionals, understanding the practical implications of these reforms is extremely important. So, today's session aims to provide clarity on key provisions, compliance requirements, and the impact these reforms have on organizations and businesses. So, now I'll hand over to Pooja ji for Mangalacharan.
Thank you, Alkesh ji. Hope I'm audible.
Yes.
You are.
थैंक यू। तो मंगलाचरण के लिए सभी को सादर जय जिनेन्द्र। अपने दोनों हाथ आनंद केंद्र पे और आंखें कोमलता से बंद। नमो अरहंतानम, नमो सिद्धानम, नमो आयरियानम, नमो उवज्जायनम, नमो लोके सवसाहुनम। एसो पंच नमोकारो सव पाव पनासनो, मंगलानंचे सवे सिम पडमम हवै मंगलम। विघ्न हरण मंगल करण साम भिक्षुरो नाम, गुण ओलक सुमिरन किया सरे अचिंत्या काम, सरे अचिंत्या काम। सदानंद स्पंद प्रवति मनोहारि वदन, प्रशस्तं वात्सल्यं स्फुरति सुखदं नेत्रयुगल। विकासो विन्यस्तं विमलमुपयान्ति दृष्टिरनिशे, जगद्वंद स्वामी विशद चरितो नाम तुलसी। जगद्वंद स्वामी विशद चरितो नाम तुलसी। ओम अरहं।
Thank you, Pooja ji, for Mangalacharan. Now I would like to call upon our TPF Bangalore Central Secretary Varsha ji for her opening remarks and welcome address. Over to you, Varsha ji.
थैंक यू अलकेश जी। आराध्य के चरणों में वंदन। वंदे गुरुवरम, वंदे गुरुवरम, वंदे गुरुवरम। A very warm welcome to everyone present here. Uh, it gives me immense great pleasure to welcome you all to today's webinar. On behalf of the TPF, I extend a warm welcome to our respected speaker, Mr. Vivek ji, and participants who have joined us today. We are truly grateful for your presence and for taking time on this Sunday morning to be part of this session. Webinars like this definitely provide a wonderful experience and opportunity to share knowledge, exchange ideas, and learn a lot from one another, and especially from today's speaker. Today's session promises to be informative and engaging. We are honored to have our speaker, Vivek ji, who will share his valuable insights around the labor law. Before we begin, I would like to thank everyone who worked behind organizing this, the convener, the leads, the complete webinar team. Once again, a warm welcome to all of you. As you all know, TPF has this monthly webinar. So request everyone to join on these webinars. So every time it is a different topics altogether. So that gives a different scenarios or different perspectives, different domains. And we have all the expertise to take these webinars. So join our webinars whenever you get to know or you get to participate in this. So welcome you all once again. Thank you.
Thank you, Varsha ji, for your welcome address. Now, before handing the session to our eminent speaker, Mr. Vivek ji Setia, I would like to give a brief introduction of him. So, Mr. Vivek Setia holds a BCom, Bachelor of Commerce from Christ University in Bangalore, and is an LLB from BMS College of Law from Bangalore. From the past 5 years, he has been practicing before the High Court of Karnataka, focusing on commercial and civil litigation, and has successfully handled several writ petitions and criminal questioning matters. Apart from litigation, he also advises organizations on employment law, HR compliance, and post act matters, helping companies build legally compliant business workplaces. He practices through his independent legal firm with legal advocates and solicitors, where he provides practical, strategic, and solution oriented legal advice to individuals and businesses. In addition to his professional firm, he is also serves as a joint secretary of TPF Bangalore West Branch. So we are delighted to have him here today. So over to you, Vivek ji.
सभी को सादर जय जिनेंद्र. Thank you, Alkesh ji, for such a warm welcome. Thank you, Varsha ji, and thank you all the participants for joining on this Sunday morning and sparing time for the seminar. And wishing all the ladies here Happy Women's Day. So, how's the Sunday, everyone? I hope everyone's had their breakfast and prepared for this seminar, so that this is intriguing for them and they can have the knowledge shared. So I will be presenting my screen. Alkeji, shall I start or do we wait?
I believe we can start. We have around 20 participants, so we can start in the interest of time. It's better.
Sure, I will just share my screen. Just give me a moment.
Yeah.
Just a second.
Oh, sure.
Alkesh, there is some issue. Just give me a moment.
Yeah, no worries. You may-
We'll just wait for a second as Vivek ji share his screen and get started.
In the meantime, I would request everyone if they have any queries with respect to labor law. Okay, so it's done. They can ping in the chat as well.
Yes. Is the screen visible?
Yes, sir.
Vivek.
Yes. Any queries that we have, we can park those questions for the end so that we don't lose the connectivity or the continuous process or the knowledge, so that we can answer the questions at the end with very swift manner. If that is all right, we can begin.
Yes, Vivek ji.
Yes,
Yes.
we can begin.
Yes. So the seminar that we are, the entire process or the entire labor law that has been amended by the Indian law system, the reason or the main purpose for doing that is before doing this 2025 amendment, we had 29 labor codes that we used to do or we used to manage for each and every aspect or each and every person for managing their business or the professionalism. So right now, the four codes that we have after the amendment are these. One is your wages code, which manages the employee wages, the minimum amount of labor has to draw from any business. Then the rules for bonuses, deductions. What are the deductions which were allowed or permissible under the Indian law for the employees. Second were the industrial relations. जैसे अभी आपको if there is an industry, you know, a lot of misuse is happening, a lot of overtime things happen in industries. The safety standards have to be maintained because the employees risk their life for maintaining or working in the industry. तो अगर उनका welfare नहीं देखा जाएगा, so if those people their welfare is not taken care of, how will the productivity happen? The businesses, the laborers or the employees are the primary backbone of any industry, whether it is a business or an whether it is an industry or a business. Laborers or employees are the backbone. तो उनके लिए there are a lot of laws that have come up. One is firing, immediate firing. अब आपको मालूम है all the corporate employees are very well aware how the hiring happen and how the layoffs happen. And India right now, a lot of people are suffering from layoffs as well. बड़े बड़े organizations जो होते हैं, instantly they just turn off one particular project and say that whatever employees or the people who are associated with that particular project are fired, or this is your last working day. After this, you can join anywhere else. We are terminating this particular project. So if that those things are happening, we need to be very well prepared कि उनका safety कैसे देखा जाएगा, because businesses are big people. They have money, they have all the financial backing as well as the legal backing with them. But what about the employees or the wages, laborers who work on wages? उनके commitments रहते हैं. Now there are recent lot of things that have happened. Big established people, they had good jobs earning 1.5 2 lakhs a month. They had a lot of EMIs, they've planned their commitments as per their salaries. Suddenly they have been laid off. The entire commitments, the entire family, everything, every person comes at stake. The liability of the family, the EMIs, they're not able to do that. And then they have taken home loans. The home loans, the properties get mortgaged with the bank. The bank takes certain actions on them. Why? Because of the loss of jobs. They have lost the commitments they had planned as of their uh, current salary, current CTC, which they draw in hand every month. But suddenly the layoffs happen because of termination of any kind of projects or termination of their employment. So these are the industrial code relations or the employment laws which protect these employees or the employees who are working in any organization. Third is the safety code. You're working in an organization with you're contributing as an employee to the organization, your time, your hard work, the entire day of your life, 8 days every day for 5 days. Certain industries work 6 days. The corporate employees are very well aware they have to work on seventh day on Sunday also if this is a busy season, especially for the CAs who are working with big fours, KPMG, EY, or any other organizations. They have to work even on Sundays. There's no time deadlines. There are the targets are so bad that they have to work on their leaves and also all those things. So the safety code, this covers about the working hours, what are the work hours, what are the primary safety measures that has to be taken in the organization, what are the what are the working hours, what are the health and welfare. Then comes and also the PF, ESI, employee state insurance, provident fund. All these also comes with the organizational safety code. Second is the last one is your social security code, which covers the PF, ESI, gratuity, and maternity for the female employees. Because that is one thing where most of the females are suffering because they are, see, there's once they are into their maternity, the job stability is the first thing that they lose because the productivity goes down. Every employer who is having a female employee, the productivity of that employee goes down during the time of her maternity. And she also needs financial capability or financial backing to maintain herself during that particular period. Because if that period is, she has a lot of other things or other traumas, or not trauma, other emotional emotional backdrop that happens to her. So to maintain all those things, the maintain the maternity leaves or the maintain maternity leaves and the payment or the salary during that time has to be given. The fourth point is the gig workers, the Zomato, Swiggy, and all those other people who also work, but they were not included in the prior labor laws or prior employment laws. But the recent amendment has brought these people also under the same bracket, which says that they are also equally and also a employee for the company, and their safety, their PF, ESI, everything safety measures has to be taken for them. So, before going to the four recent amendments, I would just like to bring the notice of you people about the laws that were already existing, the 29 laws that I was talking about. So, there are four categories in this. One is your wages and pay. For wages and pay, there were around 12 acts, 8 acts separately for payment of wages, for minimum wages, for payment of bonus act, equal remuneration. So if I will just give a brief one-liner introduction about all these so that we get an idea what exactly has happened in the current amendment that is carried out. So payment of wages, what are the wages, how much wages has to be given to every employee as per their standard of working. Second is minimum wages act. Every person has to be protected of certain sums of money that he or she would draw for working in an organization. Third is your payment of bonus act, the way the bonus have to be calculated, how the bonus has to be given. That was a separate act which was made. Then you have equal remuneration act. Every person equal pay, equal parity. That is the recent hot topic going on. Equality of payments for men and women or any person who is working as an employee. Then comes the industrial relations, the trade unions act. Now every industry, every business has employees who are working with them. To protect them, there are trade unions that protect them. If their rights are violated, these trade unions come in picture and they say that no, these are the things that you're doing wrong with your employees or your laborers. These has to be taken care, and that is where these people come into the trade unions. Then you have Industrial Employment Standing Orders Act, wherein the employees or the industrial employees can do a strike wherein anything is going wrong if the payments are not received or the salaries are not received on time, or there's some health issue or anything, health and welfare or the environment of the office or the industry is not as per the standards, and the laborers or the employees are suffering because of that, that was a separate act. Then you have industrial dispute, any dispute between the management of the company and the employees, that also there was a certain separate act. Then you have contract labor, every labor who can be given a contract for 3 months, 6 months, after that the employment termination happens. Then comes your self safety and welfare, and then the social security that we were discussing about. Moving on next. So now I will be discussing about the new changes that has happened. That is a 50% wage rule. As per the basic salary as the CTC, what was the prior thing? The CTC comprises of lot of elements: your basic salary, your DNS allowance, and your other elements which comes under the basic salary. But now what has happened? The basic salary, the CTC, 50% of the package or the CTC that we have has to be the wages, has to be
हाँ
given as a salary to the
पढ़ाई
employee.
पूरे दिन की पढ़ाई हो गई
Ji? I guess somebody had some point to make
Yeah,
out.
you can continue, Vivek. I have muted.
Yes, please, yes. So after, so why this was being done? The industries or the businesses, to avoid paying PFs, provident fund. The PF calculation happens on the wage or the basic salary that the person is drawing. Now, if that salary was not 50% of the CTC, the PF is saved, because on that basic salary, 12% is given as your PF, contribution to PF. Now, if the salary is less, businesses were not making it as 50% of the CTC, so that they could avoid that certain percentage in their provident fund giving to the employees. But for the benefit or the welfare of the employees, what now the government has done, the 50% of the basic salary has to be CTC. The CTC's 50% has to be the basic salary, no matter what the salary the person is drawing. Then because of this, there's also an indirect effect on the gratuity. Now, gratuity is also calculated on the basic salary that a person is drawing. If the basic salary is increased to 50% of the CTC, the gratuity that the person is receiving after a tenure of 5 years, that also increases. So these are the things that the changes has brought as an advantage to the employees as well as the laborers. Next, you have the second part of the same act is the fixed term employment, wherein there is separate contracts or fixed term. One is your permanent employees, one is a project-based employees. Fixed term employees comes under the project employees, wherein these people are hired for a specific term, but they get the similar kind of benefit because they become a full-time employee or a fixed term employee of the organization. So they have the same rights that a normal employee who is a full-time employee draws, or the rights that they enjoy. That is the same wages and the benefits that the worker get. Then they have employment or the appointment letters that they give to from that organization, so that the employees are also full-time. And see, because of that, they don't have to, if the business has an employee who's not on contract, these employments are at doubt. Any day the employer stops paying them the salary, they have to run towards court and then get their respective pays. But if they have this fixed term employment, they can have their appointment letters. With the use of appointment letters, they have a strong backing to get the fixed wages or the amount which they have rightfully earned because of their employment. Moving towards the next slide. Then you have the social security and the appointment letters. As I was discussing before, with the CTC having 50% of the CTC as a basic wages gives a practical increase in the provident fund contribution. Coming to the same part, the first part, that is a provident fund, which is any business having more than 20 employees working under them, they are compulsory and mandatory to register under a PF scheme, and also a scheme called ESI, Employment State Insurance. These are the mandatory registrations that they have to do. Why this is beneficial for the employees is that they get a safety and security of provident fund, and also employment state insurance, wherein if any employee has a salary below 21,000, they are covered under this medical insurance. They and their family members can use this for claiming certain benefits or insurance benefits or medical benefits during time of when they are suffering from any kind of emergency situations. Then the most discussed point, maternity benefit. Every employee, every female employee has a maternity benefit for 26 weeks paid leave. Any employee can take that, and that is their right. It is not an option that can they take it or not with the consent of their concerned manager. This is not how the maternity benefit works. Any employee who is in her maternity can take this kind of a leave no matter what the organization or their managers tell them. It is a paid leave and it is a right that is given by the labor law or the employment laws that protect us. Then you have the new concept which about the gig workers, which I was discussing about. The platform workers, gig workers like Ola, Swiggy, Zomato, every people, these people even deliver the products at 11, 12 a.m. in the night when we order. These people also do that. The persons or the employees who deliver these things, their safeties are not taken care. You would have heard a lot of accidents being happening in the night because of the delivery. They promised that they would deliver within 20 minutes, something like Blinkit. They say that we will deliver any product within 10 minutes. What about the safety of those people who are driving those vehicles, getting the things delivered to us in 10 minutes? So they have to be protected, and that is why they are also made of fixed term employees or a full-time employees of the company. They also have that kind of a right to claim the specific wages or the salary which they have to legally get without any hassle. They cannot be just randomly fired. Today, they didn't like the environment or the work of that particular employee. They say that from tomorrow you're not supposed to come. They also get that kind of a safety. They can also work. Then the appointment letter that I was just discussing with the gig workers, every employer must give a written appointment letter to every employee, which includes the following essentials. That is the job role, their salary, the working hours, leave policy. Also should include PF and if they are eligible for ESI, that is ESI, employees state insurance, if their salary is below 21,000. Not every employee is eligible because most of the people draw higher salary than ESI. But still, this is specifically for the gig workers who draw less than 21,000 as their fixed salary. I'm not talking about the incentives. This is a fixed salary that they are drawing legally every month. The variable pay, as the variable pay which they have the commissions on the number of deliveries they do, that is a separate concept that can be dealt separately. Then so this is the mandatory thing. Now coming to the side of a business person or an employer, how this particular change or the concept of all these things are going to affect them. I'll just move forward with that. Just a second. Yes. Then there is a change in the working hours, women night shift, and the leaves and holidays. Coming to the working hours, the employment law says that 48 hours has to be the minimum working hours. There cannot this is the maximum working hours. I hope everybody remembers about the recent controversy that we can work for 70 hours a week, that the recent statement which was politicized. I hope everybody is aware, and they were also criticizing the same statement to some extent. Ki if we are working for 70 hours, when do we get time for our family and friends and our personal recreation time? I hope everybody, if so, I just want the views of the people on this particular concept of 70 hours. If they are actively listening to this seminar, please they can type a Y in this. And if they are not being aware about this, they can type a no in the chat box. I'll just wait for a minute for that. If that is all right, Alkesh ji.
Yeah, Vivekji, no worries. Yeah,
Just
we,
want
we
to
would
know,
like to hear. Yeah, we would like to
just want to
hear
hear about
from the
that.
people. Yeah, yeah.
No. Yes. So moving forward, the next thing is the overtime for a day the employees are supposed to do is not more than 12 hours. Specifically, these are followed in the factory, shop, or office. They have to follow this. These are not applicable, or these are not including the corporates, because they have certain other boundaries that they have to take care about. But the major exploitation happens within a factory. Those who have more than 20 to 25 workers, or 50 workers or laborers, and the production, because in these industries the production activities, whether it is any kind of an industry, production activities are the major reason why the exploitation happens. They give them overtime. They say that no, even if you're fine with it, you have to work 24 hours a day, or maybe 18 hours a day. You're just supposed to sleep 4 hours or 6 hours a day. This is how the conditions of the laborers are. But these acts, they have brought these specific changes so that these people do not exploit the employees who are working under them. They should be capable enough to maintain these employees, because the employers are getting benefits out of the employees. If the employees are not aware about these things and they get exploited, saying that okay, theek hai, if I'm drawing some another 2 hours of bonus, or maybe 2 hours of overtime every day, I can still work. Even after working for a 12 to 14 hour shift, they're still willing to work for more than 4 hours for their overtime to draw more salary. Then there are flexible hours allowed with the contract. It's not a fixed rule that you're working from 9 to 8 or 9 to 9 as in an industry. You can have a flexible time to certain extent. The basic benefit of giving a break, so that the person can have certain peace of mind, and he or she doesn't become a robot continuously working. There is no break for that person or things like that. Second, now coming to the women night shifts. See, as we are discussing about the equality between men and women, equal parity of pay, then the third point that comes in, why are women not allowed to work in night shifts? That is also one key point that has been getting highlighted. And because of that point being highlighted, now there are changes in the women night shifts also. So before this being passed, every corporate employee or a private industry were not supposed to have women employees post 6 or 7 p.m. in the night, concerning their safety, the security, because they had to provide more security to the women employee if they're working post 7. And corporate employees are very well aware about these things, wherein if a woman is getting dropped, or if women is staying in the office post 7 p.m., they have to get a cab arranged for them. They have to give a specific escort if the woman is being the last drop. So these are the safety concerns they were taken care of, and they were not permitted. It was not permitted to have those employees post 7 in the industries. But now they have taken that after 7 they can work, but they should give their prior consent. It is not that if the law is imposed, these people are forced to work. It is on their consent. If that person is willing enough to work post 7, they can give a written consent from the women workers. They can obtain a written consent and then work. But even after that, the safety, the transportation for the women has to be taken care. Just like corporate employees, that a cab is arranged or escort is given to them. Even in the other industries, also they have the safety has to be taken care. Then you have the CCTV security guard and the safe premises. We are rightfully aware what kind of activities are happening with the women, what kind of safety issues they're facing, especially in the industries and the organizations. You have the POSH Act that is applicable, prevention of sexual harassment at workplace, and other employment laws that have come into picture, because there are a lot of safety concerns that are happening. So the new law also promotes that if they are working, if they are female employees or male employees, there has to be CCTV cameras installed in the premises, apart from your uh, private spaces, which are for recreation activities. The washrooms, the restrooms, the change rooms, whatever the name is, those places are not permitted to have CCTV cameras. Even though the law permits to have CCTV cameras, there are certain places or certain rights of employees. They cannot be monitored 24 by 7. Only in the place of work, where they are actually performing certain kind of duty towards the organization, As an employee of the firm, there they can have CCTV camera, security guard, or safe premises. Those laws are applicable. But when the person is on his personal recreational break, suppose if there is if it is if an employee is in a maternity or just given birth to a child, and they have the child accompanied, there are feeding rooms, there are washrooms in an office, all those places are not permitted to have CCTV cameras. Then night shift allowance are separate. Certain employers, what they do to the employees, they provide night shift allowance on a very low scale, wherein night shift allowances have to be given more than the regular pay or the regular salary that is being drawing by any kind of an employee. Night shift allowances are separate, they have to be given separately. Now coming to the leaves, this is the pain point of most of the corporate people, if I may understand that. And those people will be the highest relative crowd for this particular concept. And the employers will hate this concept, saying that these are the mandatory leaves imposed by the government that we have to give them, no matter what workload we have, what projects we have to deliver, doesn't matter. These are the basic things that we have to give. Coming to that, that is one paid leave for every 20 days worked. These are the specific laws for industries as well, because corporates still have an option of getting leaves on Sundays and Saturdays, depending on their employment, whether they're working 5 days a week or 6 days a week. Certain companies work 6 days a week legally. They have in their offer letter or the joining letter that they have to work for 6 days. But certain employees, majority of them have 5 days. Now the industries, they work 24 by 7 into 365 days. This is how an industry works. The leaves are very scarce for them. So to protect these people from being exploited, these leaves and holidays are given into picture. One paid leave for every 20 days worked. Leaves can be carried up to 30 days. So we can carry for 30 days. So this is a cumulative or a mixed bag, wherein employees also get certain benefits, employers also get certain benefits out of that. Now, before it was 40 days, now it can be 30 days that you can carry forward. Then national and state holidays by government or festival holidays has to be mandated as a holiday. Then they can encash the unused leaves at the year end. Certain companies play with the unused leaves. They say that if you do not use these leaves within the 365 days given to you as a leave calendar, the leaves will not be carried forward. Only a certain extent will be carried forward, like 30 leaves. Apart from that, if the person has preserved certain further leaves, that cannot be encashed. That gets what do you say, discarded from their account, and the new account begins on the next year beginning. But those things that has been preserved, saying that unused leaves can be encashed. Then you have the sick leave and casual leaves norm by the state rules. There's a specific concept. Corporate employees are aware about it. I'm just highlighting the same point, stating that a sick leave or a casual leave that an employee owns, certain person gets one sick leave every month. Certain employers give them one sick leave every month. That is 12 leaves for a year as sick leaves and 12 casual leaves. Approximately every employee has 24 to 26 days of leaves as per the organization standards. So that has to be specifically given. Then you have for industries, there is an inspection where the person who is working in the organization has to have a register where their payroll is entered, the employee's name is entered, they have all the details about the employees, who is working at what time, what is their shift, what is the salary they draw. That register has to be maintained for inspection. Then coming to the fixed wages or the minimum wages. A floor wage is set by the central government. There's a specific wage fixed for the laborers working in industries. No state government or no office or any industry can change this. 178 rupees per day. Any unskilled labor has to draw 178 rupees per day as a salary. They can set a higher limit, but they cannot go below this. This is the minimum wage fixed by the central government as per the labor laws. then the wages has to be paid on time. If there is a delay in the wage, there has to be a penalty or interest given to the given to the laborer. Payment minimum wage has to be revised every 5 years. See, this concept, majority of the industries revise their payment from Diwali to Diwali. Since we celebrate Diwali as the new year of any, for every year, Diwali is the new beginning. So most of the employers revisit the salaries of every employee on mostly Diwalis, but still certain employers, they do not increase their salary. It's like a contract labor. Once you have started working at one particular amount, the same amount has to be taken care. The same amount is being drawn. There is no increase in the facility. But as per the minimum wages act, the government has specifically stated up to 5 years, even if they are not increasing the salary, after 5 years the salary has to be increased. They can even increase within a year, but they have to do that increase in the wages, which covers all the sectors: shops, factories, IT industries, constructions, agriculture, and all the other possible industries. Coming to the key point, which most of the employees are interested in: hiring and firing. These are the key rules that is given for the layoffs and the employees being fired. Companies with 300 or plus workers need to get government permissions to lay off. What was this? This was 100 before. Any company having more than 100 employees would require a permission to lay off. Now that limit has increased to 300. Any company having 300 or more employees can fire a person giving a 3 months notice. That is a 90 days notice period, that they can get certain other job or security measures for their financial stability. And the termination has to have the legal or the rightful rules for firing any employee. Gratuity: 15 days salary per year for employees with 5 years plus experience. This is the gratuity benefits that they are supposed to draw. Retrenchment benefit: 15 days compensation, 15 days wages per year as retrenchment compensation for the employees working in industries. The gratuity is applicable for industries as well as for corporate employees, but the retrenchment benefit, which is a wages, that is applicable for your employees working in industries. They are earning their wages. Coming to the reasons or why these specific acts or specific rules has to be maintained by the employers, why this is being very mandatorily being followed by the people. One, the employees, if they don't follow these laws or those statutory registrations, that is a PF registration, ESI registration, or having what do you say, safety measures, all those activities, there are heavy fines that has been levied on the employers. They have to pay more than 50,000 rupees as fine for the first offense that they commit in the wages code. That is, wages code includes the safety for the women, safety for the people, having fixed wages, having PF ESI registrations. Then the second concept is of PF and ESI recovery. EPFO, Employees Provident Fund Organization, which manages the PF of the employees who have not been drawing PF or who have not got PF on time. That organizations can levy 12% interest and damages up to 100% on the employers who do not have the PF included in their salary, or they mandatory don't do not deduct those things. Then comes your government inspections. Labor officers for industries, labor officers can come and inspect any time for the organization, whether they are maintaining the standards, whether they are following the safety measures, welfare of the laborers are taken care. Those things are also there. These are the frequent violations that is found during the inspections held by the government in the industries. One, there is no written appointment letters. Most of the laborers get appointed without having any kind of an appointment letter in their hand. Second is no registration for PF and ESI. Even certain corporate companies are also suffering from that. Regular PFs are not paid. Regular ESI benefits are not given to their employees. Then you have paying minimum below minimum wage. That 178 rupees, which is fixed by the government as a fixed wage for an employee or a laborer per day. If that is also not being paid, that is a very frequent violations found during the inspections by the government. No leave records. There are no salary slips. It's just a verbatim. Everything happens verbally. The salary is promised verbally, the amount is given verbally. There is no substantial proof for the laborers to stand and say that no, I was promised 15,000 a month, but I'm just getting paid 10,000. There's no account of that salary because there is no salary slip given to that person. There is no workplace safety compliance. The washrooms are not hygienic. There are no proper lighting. The employees are made work, the laborers are made work more than 18 hours a day. That is also, there is no safety for them. Then the salary without reason, deduction of salaries without any specific reasons given, just because they want, they feel that no, this employees, the performance of the employee is not up to the mark, they deduct the salary. It is not provided why the salary has been deducted. And certain these things are also affecting the corporate employees. Corporate employees have also suffered the deductions in their salaries in the name of PF. In the PF also, most of the corporates give them 6% is paid by the employer and 6% is paid by the employee as per the law. But most of the companies, what they do is they deduct the entire 12% from the salary of the employee itself. There is no specific contribution given by the employer. That is very majoritarily happening in the corporate companies. Even though they have big brand, big names, but the corporate companies are also doing that. So that is why the investigation or the inspection of the government is required. Now coming to the registration, which category of people needs what kind of registration for the employers? EPFO registration if the company has 20 or more employees. ECIC if there are more than 10 employees whose salaries start from 21,000. Shop and Establishment Registration Act. Every industry, every business has to be registered under this. The documentation is appointment letter has to be given, attendance and leave register to be maintained, salary slips to employees, wages at least minimum wage as per the state notification, basic salary 50%. These are the concepts which we have already covered. I'm just highlighting those points again so that these points we remember these points for the further course of time. Then pay wages. Every person, every factory has to pay the wages within 7th or 10th working day, 10th day of every month. The wages are not paid on time. Then the safety and welfare, display labor notices, have first aid kits in the premises, women's safety policy, POSH Act. If there are more than 10 laborers in the office. Now coming to the different businesses have different obligations. We have a mixed crowd of people who have joined the seminar. So this is the basic difference or basic obligations that every business has from the point of a business owners or the employers. One is a manufacturing or a factory. Any person or in any business who is involved in the manufacturing activity or has a factory, they have to comply with the Factories Act. They have to have safety officer for 500 plus employees or workers. If they have 500 or more than those employees, they have to have a specific officer who maintains the safety of these workers working in that. There has to be a canteen for refreshment benefits. If the organization has more than 250 employees, then welfare officers are also appointed, where the welfare of the employees has to be taken care. Then comes your shops and retails. Shops and retails, those people also have certain obligations. 1 day off, daily working hours limits, registration under the Shops and Establishment Act. Then comes the corporate companies or the ITs and startups. Professional tax registration, PT registration is mandatory. EIC is mandatory. It is a mandatory registration. POSH policy of sexual harassment at workplace, especially for women, female employees, wherein the harassment against the women can be stopped at the workplace. IT employees are not necessary for the POSH Act. Even a small startup having more than 10 employees can have a POSH policy. Factories, they also are covered under POSH. POSH is not limited to corporates. POSH can be applicable to every industry wherever there are women employees, which has a more than 10 or plus employees. The POSH is applicable. Equal pay for equal work, gender neutral. Corporates have this belief or has this concept of equal pay. They have to mandatorily follow it because that is a labor law for them, that is a applicable law for them. But factories and industries, they have a specific fixed wages act. So there's a difference between the IT companies, startups, which laws they have to follow, and a manufacturing factory, which laws they have to follow. Then coming to the construction industry, hospitality, and logistics, these are the separate laws given for these people. So coming to the overall understanding or the takeaway from the entire seminar or the entire laws or the four amendments that have taken place, there are only four laws which are replacing the old 29 laws, which I had discussed in the prior slide, which were 29 separate laws which were governing all the laws. Now the entire 29 laws have been segregated into four categories. That is the only four categories which we recently discussed. 50% range will increase your PF contribution. It is a benefit to the employee. When they are retiring or they are claiming their PF benefits, they will have more PF which have been accumulated in their accounts. Appointment letters are no longer optional. Every person has to receive an employment letter. No non-compliance of these terms, ESI, PF, or maybe not having the safety measures or any of those non-compliance will be fines, recovery orders, court cases, and reputation damage. Then then I would like to just have a discussion about the POSH Act, which is more important as we are celebrating Women's Day today. So this is an awareness that I would like to bring to the women who have participated today. Actually, the POSH is also applicable to male also. Certain officers have reported cases for POSH by a man against a woman, but that scenario is very rare. But the actual scenario that actually happens or mostly happens is a woman or a female getting harassed by their co-workers, by their managers, by the persons having authority, their bosses as well. This is an independent act. It is applicable to a lower employee who is just a trainee or an intern or apprentice in a company to the management of the company, because POSH Act has a separate team. The management of the company is nowhere connected to the POSH Act. There are one or two people representing from the company side, but this is an external unit. This is an external employment unit which is there in the company protecting the rights of the men. So it is applicable, as I had already mentioned, that it is applicable to offices, factories, shops, NGOs, hospitals. POSH is not limited just to your IT companies and startups. Even a small factory having like 25 employees or 30 employees, that also has POSH. POSH can be reported. That is not awareness. People are not aware कि हम लोग shops और factories में भी POSH report कर सकते हैं. हम अपने मैनेजमेंट के खिलाफ पॉश रिपोर्ट कर सकते हैं. ये हमारा राइट है कि अगर किसी फीमेल एम्प्लॉय के साथ कुछ गलत हो रहा है किसी भी वर्क ऑर्गेनाइजेशन में, हम उस चीज को रिपोर्ट कर सकते हैं, नो मैटर व्हाट. देन if the POSH Act is not complied, the company has to pay 50,000 as compensation for the first time. Second time, the license can be cancelled, or business license can be cancelled. And if the same thing continues, business registration and double fine, all these penalties are given. I'll just tell you the formation of a POSH committee. As I was saying, it is an external committee. I'll just tell you कि POSH committee बनता कैसे है. This is specifically important for the employers who are either not registered as a POSH compliant or they are looking for a POSH compliant. They should have the basic awareness or knowledge कि POSH committee बनता कैसे है. The step there are this is divided into four stages. One, there's an internal complaints committee that is called ICC, where there are four members, and the presiding officer is a woman. Because this is a specific act for women, the presiding officer or the deciding authority is a woman. Then there has to be one external person who is from an NGO, who also has a legal background, and half of the ICC members, that is out of four people, two people minimum has to be women. committee can have any number of members. Minimum number of members as per the law is 4, out of which 2 people has to be women. One is a presiding officer, one is from an NGO or a legal background, which is an external member. The other members can be from the company, who are appointed as the committee members from the company side. These people who are external are mostly from the employees side, because the employers are partial to some extent at certain cases. They do not act swiftly on the complaints of an employee. So that is the reason the external people are appointed. These people can act on the complaint given by the employees personally. Then there has to be a written posh policy in the company. What is there in the posh? What activities are considered as harassment or posh, which falls as an offense under posh, and everything has to be displayed, that this is a posh policy of the company. These are the do's and don'ts that we have in every organization, whether it's a small business, small industry, or a hospital or an IT company. Posh policy has to be displayed publicly. Every month, every year, there has to be a awareness programs which is conducted for the employees who are either freshly introduced to the company, or the old employees who might have just taken the posh policy for granted. Ki, acha, now I know what is happening. I am okay. It is just to make them remind of the posh policy that is existing in the company. And the complaints which is given to this ICC, that is the committee, internal complaints committee, it has to be resolved within 90 days. 90 दिन की कंप्लेंट होने के 90 डेज के अंदर इसका रेजोल्यूशन निकलना चाहिए. There has to be a proper resolution passed. What was the action taken against the harassment activity? Then there has to be an annual posh report. किस कंपनी में कितना posh की cases आए हैं, because there's a external team as an internal team, so they cannot be a data breach, or there cannot be a possibility where the data is hidden. हमको the posh company, any company with a posh compliant has to report their data कि what are the posh cases they have received and what was the resolution they did, in what time they did the resolution. सारे चीज provide करने पड़ते हैं. Then you have the Shops and Establishment Act. These are for small offices, small shops who have been registered. Then you have Contract Labor Act. Then coming to the critical benefits of the employees, that is Gratuity Act, Payment of Bonus Act, and Maternity Benefit Act. Gratuity Act applicable for any organization having 10 or more employees, payable after 5 years of continuous service, max ceiling of 20 lakhs. So this one point is important for us. This has been enhanced, and now the limit for a gratuity benefit to be claimed by any kind of an employee is 20 lakhs, which has been enhanced from the previous limit. And within 30 days of resignation or leaving the company, or death has to be given. And if this is not followed, the maximum there's an imprisonment of 2 years. If any company fails to adhere to these terms of the Gratuity Act, they can suffer imprisonment up to 2 years. Then you have Payment of Bonus Act for 24 more employees having salary more than 21%. Minimum bonus is 8.3% of annual salary. As per the Payment of Bonus Act, every person can draw 8.3% as bonus minimum, and maximum is 20% of annual salary. After 1 year of service, this Payment of Bonus Act comes into applicability. And within 8 months of the financial year end, the bonus has to be paid. Coming to the maternity benefit, I hope we have women crowd we have women crowd in the audience, because we have a lot of things that we are discussing about women's today. And as this is a special day for women, and this is celebrated all over the world as a Women's Day, so I'm just reiterating the Maternity Benefit Act. How many women are there in the audience? If I may just pose this question, please raise your hands, or give me some action so that I understand how many women are there. Or are there women in the audience? All the women's, either please turn on your videos if possible, or post a Y, or raise your hands, so that I can get to know what's the number of women today. Because this is also empowerment session for women as well, because these laws, these knowledge or information, women should also be possessing. It's just not only for the male. This is specifically for the women because a lot of benefits have been added or made aware to the women also. Coming to the maternity benefit, this is applicable for any organization having more than 10 employees. Now, people working in startups having 10 employees, 15 employees, they are not sure or aware that maternity benefit हमको मिलेगा कि नहीं मिलेगा, क्योंकि उनको आइडिया नहीं है कि मैटरनिटी बेनिफिट ये एक एम्प्लॉय के लिमिट पे होता है या एक कंपनी के ऑर्गेनाइजेशन पे होता है, ये खाली आईटीज में होता है, बड़ी कंपनीज में होता है नहीं. दिस इज अ वेरी बिग myth that most of the women or most of the people have. मैटरनिटी बेनिफिट हर वुमेन को मिल सकता है इफ देर आर मोर देन 10 एम्प्लॉयज इन द ऑर्गेनाइजेशन. 10 एम्प्लॉयज से ज्यादा है तो दे द एम्प्लॉयर्स आर राइटफुली रजिस्टर्ड विद दिस एक्ट. एंड अगर वो इस एक्ट से रजिस्टर्ड है तो हर एम्प्लॉय को ये बेनिफिट देना मैंडेटरी है. 26 वीक का पेड लीव फॉर फर्स्ट 2 चिल्ड्रन, 12 वीक्स फॉर द थर्ड चिल्ड्रन ऑनवर्ड्स. For the first 2 children, it is 26 weeks of maternity leave. For the third child, it is a 12-week leave. Work from home option is available, and this is used by the startups to some extent, that they provide work from home opportunities. Then they cannot dismiss any employee just citing a reason of maternity benefit, maternity leave. I have come across a lot of organizations, a lot of people being laid off, citing the reasons that either they have announced their pregnancy or maternity, or they are about to have family planning. There are a lot of organizations that they have done. So this particular act covers ki you cannot fire an employee just because they are undergoing their maternity. There should be substantial grounds for firing the employees because the organizations are very well compliant with these acts. Then we are coming to the Equal Remuneration Act, rights of persons with disabilities, professional tax, which the companies are registered with. Now I'm opening the floor for the open question and answer session, so that if anyone has any kind of questions, we can take those questions up. Alkesh.
I mean, that was a great session, sir. I mean, I would like now everyone to, in case they have any questions, they can unmute themselves and ask to Vivek ji.
Good morning.
Good morning.
Thank you, Vivek ji. Excellent presentation.
Thank you, sir.
Just would like to know one thing, whether
Yes.
this 50% concept will be applicable to variable pay, incentive and gratuity also.
See, the CTC, there are two components in a salary that we offer. One is a fixed pay and the variable pay.
Right.
Variable pay is a separate concept. So CTC includes both the aspects. Fixed pay is what 50% covers. The salary, 50% of the CTC is the basic fixed pay that we are talking about.
No, if it is mentioned in the
Because
appointment
PF is
letter,
calculated
say
on
there are
that.
certain company who are making, say gratuity variable pay as part of CTC. Some company are making CTC plus variable pay and gratuity.
Correct?
So whenever it is part of CTC, you mean to say it will be 50%, otherwise no.
Yes. Yes. Otherwise, no. Because the CTC, if it is including the variable pay, that has to be the salary or the minimum basic salary.
So in that case, there is a lacuna in the law. People can do this by making CTC plus variable pay to get away with PF and gratuity benefit,
See,
extra
uh,
benefit which now government is providing by this law.
the law is trying to cover the lacunae. Slowly, even these changes will also get amended. If there are certain certain lacunae that is there, there will be certain more amendments coming following through for covering these things.
Thank you. Secondly, just wanted to know about overtime. Overtime will be applicable to all from top to bottom, say worker to the top management.
Yes.
Even top management, including CEO, it will be applicable overtime.
They do not draw overtime itself, right? Because
They
they
don't
have
draw
fixed
by
working
law
hours.
now. By law they are saying that if you work for more than 8 hours,
Correct.
there will be overtime 50%.
Yes.
So whether it is
It
applicable
is
to only
applicable to,
worker,
yes, it is applicable to everyone. It's not a specific category that the overtime law is applicable for.
so if employee are working in our company, say at the top level, including CEO, we have to
Correct?
pay to them.
Yes, sir.
Oh my goodness, great. Thank you.
We
Secondly,
wait
one more,
for
if I can ask, this retainership, lot of company they keep consultant and retainer.
Correct?
Same kind of breakup. We have to provide them like PF, ESI, gratuity. If the contract is 1 year and more,
Correct.
we have to provide all the PF, ESI breakup.
See, there are two types. One, see, PF ESI is for their fixed role employees or payroll employees.
Right,
These consultants are not directly a payroll employee for the company.
right.
There's an external, these are an external source of employees that they hire in the company.
But now I think they are covering all the employee who are on the fixed term. Fixed
Correct.
term definition say that all kind of person, including retainer, consultant, they will get all the benefit which regular employer are getting.
Correct. Definitely,
So
sir.
if yeah, so in that case, if regular employee are getting PF, ESI gratuity, they should also get.
Yes, they should be getting that.
So
See,
if they are
ESI
getting,
is
then people,
applicable for 21,000 and above and below.
yeah, we are talking about above this basic limit.
Okay.
So if we are giving any contract to retainer, say for 2 year or maybe
Correct.
more than 1 year,
Uh-huh.
normally we pay monthly some amount and deduct TDS.
Correct.
Now then we have to provide all the benefit. Then it will not be part of company cost. They will always make breakup of the retainership.
Correct. Because they are also, these benefits were not offered to them, and that is why they have also been included in this particular law, stating that these people should also be getting a equal pay, as in they should also be treated as an employee of the company, even though they are a retainer or a consultant.
Exactly, exactly. So same breakup we have to give them also then.
Yes.
Good. Thank you.
Thank you, sir.
thank you, Vivek ji, for addressing the query. So I have one question. I mean,
Please.
like we know that many MSMEs and startups are often struggle with the compliance framework and related things. So is there any relief to them, or I mean, they are also being penalized or something like that? Will there be any relief to
As in,
MSME and all?
leaves as in what
I mean,
exactly?
in terms of the compliance framework and all, will there be any reduced penalties or something to them? Because many times, small startups and MSMEs struggle with these compliances and all. So it becomes hard for them to comply. It increases their compliance cost too. So in
But then
respect of
having
that.
those compliances or being compliant with the law, they are protecting the employees are getting protected.
Okay. Okay. So you mean to say that the compliance may be boring, but it definitely is I mean that
It's a
the
mandatory
non-compliance will be expensive. I mean, in case.
exactly.
Okay. Okay.
So having what do you say? Having been complied or having been compliant with the laws is a mandatory thing because they have people working under them.
Yeah.
Now,
Correct.
if you're not being compliant and there are certain problems that happen, even the company gets dragged into it. The legal costs increase because of being non-compliant. But if they are compliant and the employee, see, the compliance can affect the person in two aspects. One, the business is not compliant and the labor or the employee is suffering. Second concept comes when the company is compliant, the labor cannot or the employee cannot misuse them because they are compliant.
Correct. Yeah.
उनका फायदा नहीं उठा सकते they cannot have a misuse of the laws existing because these people are already aware कि what are my rights, what are the things I have to offer, and what are the things I can take back from the employees. Are the working hours, the safety? If I'm offering these, what are the things I can take back from them? They have to be proper on the work. They should have their due diligence has to be done. They have to be perfect on their duties. They cannot be just randomly filing complaints against the company because we are already compliant. But if we are not compliant, see, it's just like a partnership firm or any other organization which is registered and not registered. Any partnership firm or any company which is not registered, any person can file a case against them, take them for a ride because you are not compliant.
Right.
You are yourself, if you have done something wrong, you cannot protect yourself from something being wrong happening to you. You can be wronged anytime.
Correct. Got it. Got it.
So this
There
is
is
the
one more.
reason the compliance are mandatory. Yes.
Okay, so there is one more question in chat
Yes.
box by Rakesh ji. He says that if all the benefits of payroll employees are given to consultants, then what would be the difference between the two types of employment? Um,
See, the difference between those employees, these people work on a limited project or limited purpose, who are your consultants. They are specifically for those specific roles, and they are not on the regular payroll, because there are a lot of prohibitions, or a lot of times not everybody can become an employee on a payroll. There's certain mandatory registration. Now, if I come now, as we all are professionals, there are a lot of CAs, doctors, or CAs, CAS, advocates. These people cannot be associated with any company as a full-time employee, because they have their certification of practice that they have obtained from their designated authorities, from ICAI, ICS, ICSI, all these organizations, Bar Council of India. So these people have specific registrations that is done. Now, if these people also become full-time employees, that is the concept of consultants or your retainers. So that is a major difference, and that is the reason these concepts have been highlighted.
okay, got it, got it.
Are freelancers covered as consultants? There's
Oh,
another question.
um,
I guess there are a few questions in the chat box also, Alkesh.
yeah, I'm seeing those only. So, the one question was posted by Vikas ji.
Ji.
So it was related to for PF calculations. So there is an option of rupees 1800 per month or 12% of basic. Is there any change in the 1800 minimum for PF?
No, there is no
So,
specific changes or changes in the PF calculation, minimum and maximum. That has not been changed. It is just the salary slabs have changed, and because of that, the PF amount has changed.
got it. So we'll take one more question. In the interest of time, and we have already crossed our time. So it's related to, it is being posted by One Plus CPH. I don't know who it is. Are freelancers covered as consultants?
Yes, freelancers are basically consultants,
Okay.
but they are not treated as full-time employees. But again, it depends on the reason or the aspect, though those people, those freelancers are associated with the company. Is it only for one particular project, or they are continuing with their freelancing or the consulting services that they provide? Is it a time bound, or is it uh, for an extended term or extended period?
So I guess there are no other questions. We can proceed with concluding the session. So firstly, I would like to thank you for that insightful and enriching presentations. I believe generally we feel that labor law is quite boring and all, but you made it very easy. The changes you covered, what the implications the business will have on their uh, the compliance requirements, the framework and all. So it was quite, knowledgeable. And so I'll now like Surajji to take over and in case he wants to add something.
Yeah, Saada Jai Jinan Sabhi ko. First of all, a huge applause and thanks, Vivekji, for this wonderful session, because I think was a very mandate and important session, not only for each individual startups, and also disguised being a great presentation in a quite a summary format for each of the industries, whether it be transport or hospitality. I hope this is very helpful to each of our audience from a different varied backgrounds, whether it may be the startup industries, some of the entrepreneurs, and also the industry heads. Thank you for taking time on this busy Sunday and having this coordinating this session with TPF Bangalore Central. I would like to thank the entire team who has been working behind the scenes, especially Alkesh ji, the convener of this webinar, and Tripti ji, who has been coordinating with you to make sure that we have this webinar connected as soon as possible, which is helpful for all our members. I also thank our past presidents for their great for the availability and making to this webinar. We have Jitendra Ji Dugar, Sir Hitesh Ji Giria, and also our South Zone Vice President Ravanji. With that, I would like to conclude. Each and every member will be having more webinars and going forward, which will help our society to grow much better. Omar.
Oh, madam, thank you to all. Can I request to share this PPT to all, please?
Yes, I will share the PPT. I will share
Great. Thank you,
the
Vivek ji.
PPT.
Very
And
good presentation, and you did, I think, good work.
thank you, sir.
Yeah, that's great.
Thank you, everyone.
Thanks.
Oh, madam, thank you so much.
Thank
Oh,
you.
madam.